Okay, today we're going to go over the exclusive right to represent seller agreement. You should have a copy included in your email, and we're going to just walk our way through it. So the top section, this is an RVAR standard form that our standard forms committee at RVAR has created. The top section is going to be going over the date of the listing agreement. This could be the same date as when the listing is going to go live on the MLS, but it doesn't have to be. I had a situation once where I was representing two sellers who were divorcing. It was a very contentious divorce. And so I actually had to go sit in with their mediator for us to figure out the terms of the listing agreement. And this was at least 3 months prior to when they wanted it to go live on the MLS. However, the mediator was adamant that we were sitting at that table, we had come to some agreements, and it needed to be documented and everybody needed to sign it. So we executed our listing agreement for one date, but the listing period didn't begin for another 3 months. So you certainly can write them up in advance. It's rare that you would need to do that. Most of the time, it's just a few days. So most of the time, maybe you're meeting them on a Monday and you want it to go live on Thursday. So this date up here is the date that you are writing this agreement, which may or may not be the same day they sign it, which may or may not be the same day it goes live in the MLS. So this date is when you're writing up the agreement. Okay. So I'm going to put in here November 11th, 2021. And then the by in between is the seller's name. This is your perfect opportunity to ask your seller, hey, seller, are you the sole owner of this property, or who is on the deed? Now, I just took a listing where I put both of them on this. They both signed it. We're a few days from closing and we find out, oops, really one of them isn't on the deed. Wasn't a big deal. We just had to do an amendment, removing one of the parties as the seller from the document. That's all. Okay. But it is a great spot to pause. You probably have already printed out the tax records. You probably already know who you think is on the deed, but it's just important to ask as well. This is when you find out, oh, actually, my adult son is now my power of attorney. Do you need to know that? Yes, I do need to know that. Your power of attorney probably needs to sign this. So that's the question I'm going to ask. Is everyone who is supposed to sign this, do I have them on the form, and are they here getting ready to sign? So I'm going to put in Sally Seller here. She's going to be selling her house. And then this next line under broker is Wainwright and Company Realtors. Because you remember from class that this is not your listing. This is the firm's listing. You are an agent of the firm, and this is not me trying to be boss britches lady. Law says these all belong to the firm. So all listings, all sellers, all buyers that are being represented by agents of the firm are ultimately, that's a service to the firm, the service to the principal broker, who is moi. So we're going to put Wainwright and Co. Realtors in there, which is also why if you leave a firm, the listing stays at the firm, because listings belong to the firm. Now, at our firm, your independent contractors agreement states that you may take your listings with you, because we are, as always, super nice. So we're happy to let you take that listing that you earned and you went out and you interviewed for and you secured. We're happy to let you take that with you. We don't even ask for a referral fee or compensation once it closes. We just let you take it with you. But of course, that business philosophy is also why we rarely have people leave us, you know. So beyond that, we have that the entire purpose of this is we're going to start using the term seller's agent. We use the term listing agent, but what they mean on here, it's going to be referred to as seller's agent. We would call that listing agent, but for legal reasons, it's called seller's agent on here. And that you're signing on behalf of me and the firm. Okay. So section 1 is real property. It is critical that you get this paragraph correct. So I want you to get and make a note out to the side. I want you to print out the CRS tax record, which is available on MLS. I want you to print out the municipalities GIS records. I want you to cross-reference those two to each other and make sure that they match what this seller is telling you they're going to sell. Do not use past listings on the MLS as your data. That may or may not be correct. We have seen lawsuits in our area for school districts being listed incorrectly. Well, the school zone's shifted. And now the buyer who's living in the house says, what? My kid isn't going to XYZ school? That's what it said in the MLS. Well, that's a pretty big deal. You should be getting your information from the most reliable source, which is going to be your seller and the GIS and the CRS tax records, okay? If there's a discrepancy there, you need to dig in and investigate and understand why is there a discrepancy, and then go to a higher source. So we're going to say the county of Roanoke, and then if available on the tax records, I'm going to put in the lot, block, section, and map of. So this may be lot 1, block 3, section 2, map of Waterfall Estates. I'm finding that information on the GIS. That's where I'm finding that. So the municipality's tax info on the GIS is where I'm finding out that information. Or other legal description, that I'm going to write in as tax ID 103.01-11.010. I'm going to put in the tax ID number there. Okay. You don't have to, you put in whatever you want to put in. Just know that what you're putting there is tax ID, whatever's on that MLS. Now, you may have a situation where you have more than one tax ID. Perhaps it's 2 parcels that are being sold as one listing. So you would want to put a comma and put the other tax ID number in there. You may put lot 1 PT2, because sometimes it's lot 1 partial lot 2 on the municipality website. People do funky things over hundreds of years with subdividing their properties. So just try to squeeze in there a true and accurate representation of what the GIS is telling you, what the municipality website is telling you. And then, and more commonly known as, this is where we put in 939 Main Street. Okay, that's the mailing, the 911 address, you know, the address for the property. Roanoke, Virginia 24013. Now, I've got the last sentence saying whether the property does or does not include water frontage. So most of the time I'm checking the box for does not include water frontage because I have made the wrong life choices and I'm not selling property at Smith Mountain Lake. So I'm usually saying does not include water frontage. You may do obviously whichever is going to be appropriate for this property. Sometimes it can just be like in Roanoke, there's several ponds and there's subdivisions built around these ponds. And so maybe it does have water frontage. So it doesn't have to always be at Smith Mountain Lake. It could be a very large lake that's been installed for a subdivision and this property backs up to that lake and they maybe have a little dock. There are some subdivisions that are like that around Roanoke. And then number 2 states, and y'all just stop me if you have any questions along the way. Section 2 says seller representation. This is the seller saying that they have not signed another listing agreement or they do not have an unexpired other listing agreement, that they have the right to enter into this listing agreement with you and that they are signing it as the only people who have a claim to be the seller of this property. Okay. This is what puts them in breach of this contract. If they actually have only sort of fired their last listing agent, but they haven't actually gotten out of that contract yet. And now we have to pull our MLS listing down because the other one isn't actually expired and that listing firm is going after this seller. That's what puts the seller in breach of this contract. Okay. That would keep us from an ethics violation of meddling with somebody else's client because that seller has signed this stating that they have a right to enter into a listing agreement with you. 3 is personal property included. This is where I'm going to ask them and we're going to walk around the house and look at it. What are we going to include in this sale? Because the reason why I want to walk around the house with them and do this is it may not occur to them that they have to leave their grandmother's chandelier unless we say that it's not conveying. If it's attached, it's going to convey. It is expected to convey. So I'm going to ask questions about things. And I'm specifically looking for chandeliers, light fixtures, maybe custom made things that are attached, affixed to the property. Maybe they've had some really custom made built-ins made that they plan on taking with them. But I don't know that. The expectation by the buyer, though, is going to be that those built-ins stay. So I'm going to be asking those questions as I walk around and look at personal property with them. And then I'm going to list them like this: dishwasher, comma, stove, comma, blah, 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 list it all out to convey in as-is condition, but shall be in safe working order. Because I want to set the expectation for my sellers right now. This is where best business practices are. Have these conversations up front so that when you say, dude, the microwave doesn't work, that isn't discovered during the home inspection. That's discovered during your listing appointment. And when the buyers, when your sellers say, oh yeah, it hasn't worked since we bought it. Well, they have to make it work now. We could have up front right now written that the microwave will convey an as-is condition, or removed the microwave. Okay. I had some sellers do that on a house. The built-in microwave, the undermount microwave didn't work, and they didn't want to do another undermount microwave. So we just took it down. The house went without an undermount microwave. But if the undermount microwave is there, the expectation and the contractual obligations to the seller are that they will convey it in working order. So this is a conversation that I'm having with my sellers up front to get in front of any situation where there's something that isn't working correctly. And if it's not working correctly, that's okay. But I need to say, if they say to me, hey, the washing machine works, but you got to like insert this ruler into the switch so that it'll jam it and it'll work. And then you got to pull the ruler out. Otherwise it runs forever. Okay. Well, I'm not saying that they have to fix that. And I'm not saying that they have to buy a new washing machine. But I am saying we're going to write into every contract that we receive. If we accept a contract, we're going to write in that the washing machine is going to convey an as-is condition. And I am, you bet yourself, I'm going to write it in the private remarks that the washing machine is conveyed in as-is condition. It does function, but quirky. Call listing agent for details. Okay. So these are things that could become big problems later, but because we're getting in front of them up front, we can address them. If the buyer's expectation is, oh, that's a weird washing machine, but okay. And the sellers are saying, sorry, we're not fixing the washing machine and we're not buying you a new one. Then the buyer's not going to be disappointed later when that's revealed later. It should be revealed up front. Okay. Number 4, this is an important question. Is there any leased equipment on the property? And I specifically say, do you have a propane tank and is it leased? Because that's the most common leased equipment, but it can be water treatment, water softener systems, water treatment systems. I even know that there are companies that lease hot water heaters. So you want to ask, do you have anything that's leased? How about your hot water heater? How about your propane tank? How about your water softener? How about your security alarm system? How about your satellite dish? Do you have anything on the property that you're paying a rental fee for that you have leased? And then you want to disclose it here. Then we're going to put in our list price, and we will have worked up a seller's net sheet. We've done that in the past. We'll do it again in the future, and we'll work on it together. But you're going to have worked up a seller's net sheet that says, okay, y'all, if we list for $275,000 and we pay $1,000 towards repairs, and we pay, I don't know, $9,000 to commissions, and we pay $150 for a well inspection, then you, seller, can expect to net X dollars from this listing price if we were to get a full listing price offer. I then use that figure to say to them, okay, well, is that going to be acceptable? Because if they say, no, we want to make more than $1,000, you know, once we pay our mortgage off, we're only going to have $1,000 if we accept a full list price offer. Well, now up front, prior to putting it on the market, we know that they may be bringing money to the table to close. For any offer that comes in below list price, they're likely going to have to bring money to the table. Now, that was another market when that was happening. I worked in that market. It was not a happy day when the sellers had to march into the closing with a $7,000 cashier's check so that they could sell their house. Who knows if we'll get back to that type of market or not? We may not. I don't know. But I've worked that market. I've worked this market. These are conversations I have up front so that I know we're pricing it right. It may be priced right for the market, but it may not be priced right for them having gotten a refi, a cash out refi 2 years ago, and now they owe too much on their house. So this is where you discover that sometimes. And I have definitely sat in listing appointments and went, uh-oh, well, we can try that higher price, but please know that that's not what the market is saying the listing price should be. But I understand that you want to actually make some money on this. Now, more commonly, they have a conversation with me where they say, oh, but we need $35,000 to buy our next house. Great. I hope you get that. But we can't base our listing price on what you need to buy your next house. We can only base the listing price on what the market is saying listing prices should be. Now, we can, I just may not. You know, I may pass on that listing. I have told y'all before, I want to be the second agent for overpriced listings. I don't want to be the first agent for overpriced listings, because the first listing period is spent with the market educating my sellers on how that price is too high. The second agent gets to step in and take advantage of their re-education and list it at a more appropriate price, and it usually sells. So list price, we're going to put it in there, but make sure you know that number is going to work. Listing period. This is now where we're going to put in, when is it going to go live on the MLS? Now, this could be in a coming soon status or just straight to active. But I'm going to put in the listing period there. I recommend 6-month listing periods right now. I have also worked in the market where 1 year is the norm for our firm, that our firm would do 1 year listings because it would take that long to sell a house, y'all. Can you even imagine? When we were riding dinosaurs and it took a year to sell a house. All right. We're going to put in our listing period there. I like to make my listings end on a Sunday. So I may do 6 months, but I'll go to the next Sunday. That's just my own personal preference. I don't like a listing to end on a Friday because I think, ooh, but what if that was the weekend? What if that was the weekend? It was beautiful outside and everybody wanted to go look at houses and they got an offer, you know? So I typically do 6 months and then I make my expiration date the following Sunday. Now, if the expiration date for 6 months ends up being a Monday, I might back it up one day and make it 1 day less. So round up, round down, but I typically do a Sunday as my expiration date. Sometimes a Monday, just depends on the mood. All right. We're going to move on to page 2, unless anybody has any questions about page 1. And now I'm going to, yes, please, Rhonda. Do you need me to request you to unmute?
What if you put in a year, which I did recently, and you don't want to be the listing agent anymore?
You're stuck. You're stuck unless both of you. So this is what we would call a bilateral agreement. Okay. Both parties, both you and your seller, have to agree to terminate the listing agreement. And I had one. I had one where I was trapped and I had to run it all the way to the end. It was Donna and Jennifer know it was a very, very uncomfortable situation. I did not feel safe representing this seller. So I just had to ride it out. Now, I will tell you, y'all are in a little bit better of a position because you can always call me because this is my listing. I can put anybody from Wainwright I want on that listing. I can pull Rhonda off and put Donna in. I can pull Rhonda off and put Rich in. I can put whoever on that listing. So if truly you are having a situation, you come to me and we can't terminate the listing without the seller agreeing to terminate it. But I can certainly put another agent on it. Now, obviously, Rhonda, at that point, I'm going to have to pay that other agent with some of the commission, obviously. Sure. You know, but you wouldn't have to be representing a seller that you don't feel comfortable representing anymore.
Okay, thank you.
You're welcome. You're welcome. And it does happen sometimes. And Lord knows if I couldn't handle that person, I've not seen it successfully sell yet. And this was probably 2 years ago. So, well, it was pre-pandemic. So yeah, at least 2 years ago. Quirky bird, to say the least. Okay, so page 2. Broker and seller's agent's duties. And what the way I pitch this to my, or explain this to my sellers, not pitch it, explain it to my sellers, is I say, these are my duties. I am going to perform in accordance to this agreement. I'm going to seek a sale for price and terms that is agreeable to you, seller. I'm going to present in a timely manner all offers and counter offers to you. And I'm going to disclose to you all material facts relating to the property that I discover and have actual knowledge, which means when we get, like Donna just got the home inspection report for one of her listings. She is now obligated to share that with her seller because this listing agreement says she has to. It says that Donna is going to disclose to the seller all material facts related to the property. So she now has actual knowledge of them because she's received the home inspection report. That is why she must share it with the seller. This listing agreement says so. It's also why the seller can't say, Donna, don't send that to me. I don't want to look at it. I have to send it to you. I'm so sorry. I can't make you open that email and read it, but I have to send it to you. And if you have a situation like that, I want you to carbon copy me on that email, even if you blind carbon copy me on the email, because I want proof later that you really did send it. If that seller tries to say, oh no, I told Donna not to send it to me, so she didn't. You know, that way you've got a third party saying, oh no, I got copied on it. I got it too. So I'm sorry that seller didn't open it and read it, but I can prove that I saw Donna deliver it. Okay. I'm going to also account for in a timely manner any money or property received in which the seller may have an interest. Now, that's typically earnest monies, but the buyer's firm usually holds those. So it would be very rare for a listing agent to hold an earnest money deposit. Okay. And then we're going to move on to section 8. If you have questions, just stop me. Section 8 is the seller's duties. And this is important for the sellers to understand. I'm going to say, seller, this is what you are agreeing to abide by. You will work exclusively with me during the term of this agreement. You will pay me the compensation as set forth in paragraph 10. You're going to provide accurate information, which is why I'm asking you, seller, what do you know of in the house that is not functioning properly? Let's get it fixed now. Do you know if the basement takes on water? Now I'm going to say, you are not obligated as a listing agent to go on a fact-finding mission. You are not obligated to make discovery, but the standard is if you knew or you should have known about a material fact, you must disclose it. The seller doesn't have to disclose it. But if the seller says something to you like, well, don't tell anybody, but the plumbing actually just dumps into the river behind the house. There's a ravine back there and it just dumps into there. Well, I either am going to have to explain to them that I'm going to have to disclose this to every potential customer, or I'm not going to feel comfortable taking the listing. Do not take listings that you are not comfortable taking, okay? Your intuition is usually correct. So I'm going to also go on to say, seller, you also have to inform me of any factors that may impact your ability to fulfill your terms of this agreement, like you're not paying your mortgage, like you're getting foreclosed on. I need to know those things. If you're having trouble with making your payments, let me know. We will workshop a solution. You're going to refer anybody who asks about the property to me. Okay. I really want to be the one who shares information about the house with them. Now, please make sure you're telling everybody you know, seller, that your house is on the market, but then hand them my business card if they're interested. And this is in all caps for a reason. Refrain from disclosing any information to anyone other than me, anything about the property. So I'm going to tell my sellers at this point, this is why I'm going to ask you to not be home during showings. I would not want you to accidentally reduce our negotiating power if those people came and brought an offer, if you've accidentally told them why you're moving, or you've told them y'all are getting a divorce, or you tell them that you're getting transferred for work. If they know you're getting transferred for work, they may decide that you have to sell, and they may bring us a lower offer than they would. So I'm just asking you to make sure you're not here when showings take place. And then G, retain full responsibility for the property, including utilities. Seller, this is why I'm telling you, we have to have all the utilities on throughout the entire listing period, and then throughout the contract transaction. And disclose whether the seller is or is not a licensed active or inactive real estate agent. Most of the time I'm saying is not. Every once in a while I'm saying is an inactive agent. And disclose that the property is or is not tenant occupied. Okay. Leases cannot be broken by the sale of the home. Leases are leases. They will last. And this gives me an opportunity to say, hey, how long is the lease for the tenant you currently have in there? Okay. Because that may change how I'm going to market this home. If they say, oh, at the end of the month, their lease is up. Well, great. Have you given them their notice? And if they say no, I'll say, you might want to give them their notice, their 30-day notice. And Anastasia is saying, ask for a copy of that lease just to kind of look over it and confirm they really have to be out. Excellent idea, Anastasia. Okay, 9, additional provisions. This is the material information disclosure. This is saying that the broker and the listing agent, seller's agent, have to disclose to prospective buyers all material adverse facts pertaining to the physical condition of the property, which we actually have knowledge of and which are within the 4 corners of the property. We have to disclose them. I don't have a choice. If I know water comes into the basement, I have to tell, no later than contract writing, anyone who may be interested in making an offer on this property. Anyone who is having a substantive conversation about the specific property must know that water comes into the basement sometimes. This is why you'll see it in the private remarks. And they try to throw that, realtor flavor on it to make everybody think it's not a big deal and say, tiny trickle during prolonged periods of rain may come into the basement, right? Well, that means the basement gets water. All right. To what degree? Who knows? But that is, and Anastasia is rolling on the floor laughing because we see that all the time, because that is how realtors write it, because we want to make our disclosure, but not scare anybody off. All right. B, residential property disclosure. Is this home eligible for the Residential Property Disclosure Act? The exemptions are easier to list. The exemptions for residential property disclosure are estate sales, foreclosures, and new construction. A residential property disclosure form is not required if it's one of those 3 types of sales. The premise is that the people selling have not lived in the home. So they can't make a disclosure one way or the other because they've never lived in the home. C, what I say to the seller is I say, seller, this is the fair housing disclosure. We are not going to discriminate against anyone for any of the protected class reasons. If they have money and we like the terms of their contract, we're going to sell them our house. Only one time in my entire career have I had somebody push back on that. It was this little old lady, and I had to say to her, no, we're not doing that. She also decided she only wanted me to show the house. She didn't want any other agents in her house. I would have to be the one to show it. And I'm like, that's not really how that works. Not how we're going to do that either. Yeah. Again, another quirky bird. Life is full of them. Okay. D, property owners association disclosure. This is where I'm going to ask the seller, is this home in a property owners association? Now, I probably already have a hunch because I've already probably done a little research on MLS in the neighborhood. And I have also maybe looked on the GIS. Homeowners associations, property owners associations, not listed on the GIS. So you're going to want to cross-reference with some MLS listings and see what it looks like around in the neighborhood. But primarily you're asking your seller, is there a homeowners association? Or, and I ask this, or a private road maintenance agreement. Because it may be that's $150 a year to a road maintenance fund for putting gravel on the road every so often. So this is my opportunity to ask them about that. E, condo disclosure, same thing. Is this a condominium resale or not? F, lead-based paint disclosure. Was or was not the property built prior to 1978? Very easy question there. G, disclosure statement for residential property previously used to manufacture methamphetamines. I'm going to ask my seller, to your knowledge, has the property ever been used, or any of the outbuildings ever been used to produce meth? And they're going to go, well, I hope not. You know, they're going to have some like hilarious answer because they all do, and that's fine. There also is a registry. There's a statewide registry for homes that have been used in the production of methamphetamines. Because that is a required disclosure, you know. And it's one of the few true seller required disclosures. There really are not that many for the seller to have to disclose. We've got loads because, as we see here, we have to disclose every material fact about the property. Sellers only have a few items they have to actually disclose: lead-based paint, meth manufacturing, couple other things. 10, compensation. This is the one I get more questions about. 10 and 11. So this is what we're going to do. Compensation is always the total brokerage. So I just want you to remember, big number on top, little number on bottom. Okay? Because 10 is for the total compensation of our firm's 6% of purchase price. And then it details how in which we will have earned that. And I'm going to go over that with my seller. These are ways in which I will earn that compensation, that commission. And I typically put 0 days in D because I feel like if I have provided my sterling service, they're just going to extend the listing agreement with me. I don't feel the need to like hold them to an extra 30 days after the listing period. Maybe that bites me in the rear end sometimes. I think it instead, in my opinion, it conveys even more trust in me that I'm not trying to hook them for an extra 30 days or 90 days or 60 days or whatever people think they're clever and put in there. I just don't do that. I'm just going to provide excellent service for 6 months. And if they feel like I've provided excellent service, they'll relist with me. Now, 11 is what we're going to be offering a buyer's agent or a sub-agent. So that's why I'm saying big number on top, little number on the bottom. So this is where I'm going to say, I'm going to check the box and say that I'm willing to give 3% of that total brokerage for the gross sales price to the buyer's agent. Now, you see that says gross sales price, which is why we cannot push back as listing agents and say, well, I see that your buyer is asking for $9,000 in closing costs. My seller wants to pay on the net. No, this agreement is that your seller will pay on the gross. So I'm going to take a moment here and I'm going to say to my seller, I want you to underline gross sales price because I want you to have this conversation with your seller. Seller, if the buyer that we get ends up asking for closing costs, you're still going to be paying commission on the closing costs. I'm just letting you know. Let's real quick look at what commission on $5,000 of closing costs would be. That is an additional $300. If you have a problem with that, and this is my custom, if you have a problem with that, I will cover that from my commission. Okay. But the buyer's agent is going to have to be paid on the gross sales price. It is a Realtor Code of Ethics violation and a breach of this listing agreement to try to pay on the net. A net would be gross purchase price minus closing costs paid on the buyer's behalf. So that's why we don't do those shenanigans, y'all. I get it. I do feel badly for my listing agent that they're having to pay on closing cost money. That's not money they're ever getting. So almost always I cover that for the other side, for the other agent. Anastasia, glad you're learning something. Yay, it was worth coming today. So in my case, what I'll say to when I'm presenting an offer to my seller is I'll say, seller, they're asking for $5,000 in closing costs. That's going to cost you an extra $300 in commissions. So what I'm going to do is I'm going to reduce my commission by $300 for you. And I'll send an email to the closing office and let them know to reduce my commission by $300. Now, a lot of times, if you've done a great job for them, they're going to be like, oh, don't worry about that, Ashley. That's fine. And I'll say, are you sure? I don't mind doing it. It's not very fair that you're paying commission on the buyer's closing costs. You're not getting that money. And they'll say, nah, it's fine. Very rarely does a seller take me up on that offer. because quite frankly, I'm working really hard for them. They understand that. And they appreciate that I've even explained this to them. Okay. But if they try to offer commission based on net, they're in breach of this contract. I don't want my seller to be in breach of this contract. They're usually only in breach of contract because I have not explained this well enough to them. Okay, then we're going to go into 11B. I see you, Jennifer. Yes, thank you. She's reminding me that I'm talking too long because we're running out of time. So we're going to go into 11B, which is disclosed and dual agencies. Excuse me, disclosed and designated agencies. Nope, still didn't get it right. Dual and designated agencies. So I'm going to explain to my seller. And again, I'm going to tell you my custom and my own rule and what I want you guys to do too. I'm not ever going to do dual agency. So when I'm sitting there representing my seller and I've just detailed all these things I'm going to do for them, I'm going to go ahead and tell them here, dual agency could happen, which is where the buyer comes unrepresented and I decide to represent them as well. But I'm here to tell you, I'm not going to do that. I don't think it's fair to you. I've just promised you I'm going to do all these things for you and I won't be able to do many of them because if I'm a dual agent, I'll be harming the buyer. So I'll be able to deliver not as much of service to you and I'll actually be making all of the commission. So I don't think that's fair. So I'm going to call another buyer's agent and have them come in and represent that buyer if we have an unrepresented buyer. I go ahead and tell them that up front. And dual agency is not illegal. It's just not what I want you doing. I have more problems with dual agency than I have with anything else. Not me personally, but the phone calls I get, okay? Designated agency just means seller. Another Wainwright agent might bring the buyer, and that would make this a designated agency situation. There's no problem with that. There are 2 brokers at the firm, and each will help an agent if any issues arrive. 12, multiple listing service. I'm stating here that we're going to put it in the MLS. It's going to go out to the widest audience possible. And I'm going to check the box in C that I am going to put an electronic lockbox on the property. If you're putting a contractor lockbox on the property, you must check the box for other and write in contractor lockbox. Otherwise, you do not have permission to put it on their property. The other thing is, if you put it on here, the seller is saying they're okay with it. So if the contractor lockbox ends up having a security issue, the seller has said it's okay for you to use a contractor lockbox. I don't like them. I don't really want you using them. I'd rather you use a super box. They're way more secure and you have a record of who's been in the house. There are probably a dozen times I could point to us having to look up who was the last agent in the house on one of our listings because somebody left the sliding glass door open, something got stolen, something's gone missing. So that super box really is a protection for you as well because you have a record of who's been in the home. D, the seller understands and agrees that we're going to have it in MLS, we're going to have it in RVAR, and that we're not responsible for any vandalism, any theft. And this is my conversation with them to say, please, right now, lock up any valuables, including prescription medications, including checkbooks, okay? We don't want to leave any of this stuff out. And I'm going to say, I am an excellent agent, but even I sometimes have buyers go 2 different directions in a house. I can't be with them when I'm touring the property every second of the tour. So please go ahead now, remove any jewelry, valuables, iPods, iPhones, anything you got that's valuable, lock it up, okay? Or take it off the premises. Take your valuables to your mother's house. Leave them at your mother's house during our listing period, okay? I'm going to have that actual conversation with my sellers so that later they can't be upset if their prescription pills got stolen because I told them to lock them up, okay? 13, authorization regarding the internet display. Almost always the seller wants their property on the internet, obviously, but there is an opt out of the internet section here if they would not. Occasionally there's like a judge or a state trooper or someone who just doesn't want it on the internet. And that's another thing to bring up. I'm going to say to them, these photos are going on the internet. If you would like to, and I had a past state trooper he had his like framed accommodations on the wall. And I said to him, you might want to take that down. You know, these pictures are going to be all across the internet, and they're going to be able to see this framed photo of you having been in, you know, in police service or working as a state trooper. And he agreed. And so he just took that down and put it in the closet. That way it wasn't in the photos. So anything that might be private in nature, you know, perhaps they have adopted children. Perhaps they want to take down their family photos before these pictures go all over the internet. And then everybody's sharing them on Facebook saying, you know, hey, so-and-so, aren't these your kids? That kind of stuff happens. So you want to just have a conversation about how we're not opting out of the internet, but please know that these photos are going to go everywhere. Okay. Is there anything that you would not want to have show up on the internet? C, if the internet display is allowed, then we're going to be checking these boxes referring to virtual office websites and what they can and cannot do. I always have my sellers initial does not authorize and does not authorize in 13C. Does not authorize third parties to write comments and does not authorize automated estimates of the market value by third parties. Now, this is not the Zillows and the Realtor.coms and the Yahoo real estates. This is virtual office websites, which are non-brick and mortar real estate companies. They're full real estate companies, but I am not authorizing that. Okay. And then 14, although I'm going to just do a sidebar here. Interesting, because that authorization, it does not apply to consumer websites that are not broker owned, like a real estate website that gives estimates to things that isn't broker owned, except now maybe has become broker owned because they're getting into real estate now and they're getting licensed now. So I wonder if that means if we check does not and does not, do they have a right to do market value estimates anymore and make those public? Anastasia, don't say anything because I know you know exactly what I'm talking about, and I'm recording this right now, so we can't go down that that rabbit trail right now. But I'm just interested to see if that might change things now that this big company online and their website now actually is broker owned. So we'll see what happens. 14, additional authorizations. Seller, you're going to allow me to put a for sale sign on the property and remove all other signs. That's what gives me the right to take down the last listing agent sign and put mine up. Now, please be careful to ask, am I allowed to put a sign in this homeowners association? A lot of condos don't allow yard signs. If anything, they'll allow you a small printed sign, no bigger than 8.5 by 11, placed in one window. Okay. So just ask if there is a homeowners association, property owners association, specifically ask, am I allowed to put up a yard sign? If they go, ooh, I don't know, ask them to ask their neighbor who had recently sold their house. Ask them to pull their most recent property owners association packet and take a look and see. B, seller, I'm going to be allowed to advertise, disseminate information about the property, including pictures, including media that I create. And C, I'm going to be able to show the property during reasonable hours. And I'm going to say to them, our lockbox is going to work. I'm going to put it on daytime, which means it's going to work from 9 a.m. to 8 p.m. at night. This is an opportunity to talk to them about whether those hours work for them or not. And then D and E on the next page say that I'm going to use my best judgment to determine how and when to divulge the existence of an offer or offers on the property. And I will inform the seller, will inform the broker if the seller is unwilling to let me disclose whether there are offers or not. The seller can say, I don't want you telling anybody if I have an offer or I don't have an offer. They can say that. But they have to let me know. The existence of offers is something I'm going to encourage my seller to let me convey to other parties. If my seller gives me permission, I can tell everybody how much the offers are for. That's not confidential. It's only confidential if the seller says don't, if the seller, excuse me, it's only not confidential if the seller gives you permission to share it. So my seller can say, I don't care, tell everybody how much the offers are for. They can say that. Now I'm going to advise them it's probably not in their best interest, but they certainly can give me permission to do that. And E, disclose or not disclose if there were any seller paid financing concessions. Now, because I love good comps and good comparatives, I'm going to make sure my seller says, yes, it's okay for you to disclose when you close this out in the MLS, whether we paid any buyer paid closing costs as part of the offer. Because wouldn't you love to know when you're pulling comparatives to do a new listing as to whether that house down the street paid any closing costs or not on that purchase price? I would love to know that. So Jennifer's saying, yes, please, 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 please disclose those concessions. It helps appraisers as well. Okay. It also means you're not going to be getting calls from appraisers now saying, hey, were there any closing costs on that sale you did in Kingsbury Court? So I encourage my sellers to disclose that. 15, recordings within the property. This is new to our form as of the last couple of years because the uptick in recording devices in homes has gone through the roof, right? So this is stating that 15A says, if the seller has a recording system which records and transmits audio, the seller understands that recording or transmitting of audio may result in a violation of state and federal wiretapping laws. Seller hereby releases and holds me and you completely harmless from any of that. Okay. Now, if they've got recording devices that are not recording audio, they're probably not going to be in trouble. But this is saying that if they do have them and they do get in trouble for Virginia wiretapping violations, they're going to hold us harmless. Okay. And D, seller understands that while potential purchasers viewing the property should not be photographing or live streaming or using videography, which is FaceTime, without prior written permission, they may occur. And that the seller should remove any items of a personal nature that could be recorded or transmitted without our knowledge. And they hereby release us from anything that may happen with that. If you are a buyer's agent and you want to FaceTime, or you see your buyer whip out the camera and say, hey, my husband's at work, I'm gonna FaceTime him. Just say, oh, I'm so sorry. I have to get permission for that first. Now they may say, well, that's stupid. Well, you can think it's stupid, but I've got to ask permission for that. So I'm going to email and text the listing agent right then and there. And I may call them and say, hey, I'm shooting you an email to see if you'll give me permission to let us FaceTime. Her husband's at work. May we please FaceTime the property? Them telling you on the phone, yes, you may, is not good enough. You have to have written permission. Okay. I know that sounds petty and unimportant, but it is the rule. So we have got to get written permission. 16, and I know we've gone over just by a minute. If you can stick with me, please do. 16, broker and seller's agent disclaimer. Seller says, you understand me, I'm the agent. I'm just the agent. I'm not an appraiser. I'm not a home inspector. I'm not a surveyor. I'm not a structural engineer. I'm none of those things. You're hiring me as your listing agent, period. And 17, seller default. If the seller defaults on this contract, we are allowed to sue them and recover reasonable attorney's fees and court costs incurred in enforcing the provisions of this agreement. We don't do that, y'all. If someone is terribly unhappy and wants out of their listing agreement, they're probably going to call me, and I'm going to call you first and say, what's going on? What's happening here? And you're probably going to say, they are the most difficult person I've ever worked with in my life. And I'm going to say, want me to switch them to another agent? And you're probably going to go, please. And then I'm going to say, I got to share some of your commission when it closes. And you're going to say, fine, get rid of these people for me. And I'm going to call the seller. I don't have to let them out of their listing agreement. Now, sometimes I will, but I don't have to let them. I can switch them to another agent. Okay. 18, this is where I'm going to check the boxes of what is going to be included with this listing agreement. This is a great spot for you to go, oh no, I completely forgot to print out the lead-based paint form. So this is just a checklist for you as well to see what's going to be applicable for this particular property. If you look at F, that's the RESPA disclosure. As long as you work for Wainwright, you will never have a RESPA disclosure. RESPA disclosures are for when my firm has an affiliated business relationship with another vendor, and we will be receiving some sort of funding for recommending or the seller using that company. The most common one would be title insurance companies who issue title insurance policies at closing. I don't have an ownership interest in any of those. I don't plan to have an ownership interest in anything else. That is not how I want to make ancillary income. Instead, I just want to stick with what I do and not require you guys to have a RESPA disclosure that you have to execute for every listing and buyer's agreement. 19 is additional terms and authorizations. This is where you may write in that this agreement may be, or what you could say is, if the seller's cousin, Betty Smith, decides to write an offer on this property, then this listing agreement shall be null and void. Because the seller may say, listen, my cousin Betty has been saying that she's going to buy this house because this was our grandmother's house, but she just is not doing it. I'm not waiting on her anymore. But this may light the fire under, and she might come right back one day on the market and say she's ready to buy it. So if I feel gracious, I may exempt Betty as the purchaser from this listing agreement. Call me if that's kind of the situation, and I'll help walk you through that. 20 says faxes are the same as originals. 21 says that we're going to allow electronic signatures. And 22 is a gigantic wire fraud alert saying, please be careful with wires, okay? And please do get on the phone to confirm wire instructions with the actual closer. 23 says this is the entire agreement. And the assumption is that this seller is the only seller, okay? And then we have 2 pages on what dual agency is and what designated agency is. I do not want you doing dual agency, okay? I understand that you believe you can do it fine and not harm either party. I'm here to tell you, I know you think you can, but all it takes is something going a little sideways and you are now the only agent and one party's getting harmed and the other isn't, and you're now in breach of one of those contracts. So I am telling you not to do dual agency. I'm frowning on it more and more. Buyers and sellers are more and more educated and savvy, which is a good thing, which means they understand that you should not be working against them when you're a dual agent and something has gone sideways for them. It gets very sticky very quickly. So do not do dual agency. Designated agency, I have no problem with. It simply means the buyer and the seller are both being represented by Wainwright agents. Now, legally, that makes me, the principal broker, a dual agent. But in those cases, we will assign Jennifer to one of those agents. And Jennifer, as one of our brokers, will handle the questions and the concerns and maybe the language writing and amendment construction to Jennifer and the other party with me. So that way you will both have independent broker support. Okay, whew, we did it. Can I ask some questions? Anybody have anything?